Hello and welcome back to my YouTube channel. I go by the name of Dr. Heinz Legal Minute. Thank you so much for tuning in for this video. Massive thank you to all the new subscribers. Welcome to the wonderful world of Dr. Heinz Legal Minute Crazy Thought Express. I'm happy to have you on this journey with me. To all my existing subscribers, do check to see if you're still subscribed. I'm hearing that YouTube has been unsubscribing people automatically. I don't know why this is happening, but do check to see if you're still subscribed. Now on this video, I'm going to be looking into Amber Heard's appeal. I'm not really going to be doing a deep dive into anything. It's just more of a touch on it. There has been a lot of YouTube channels that has been covering this. Notably, I think two creators stand out the most. I think two creators stand out the most, and these creators goes by the name of Catherine Lozando as well as Andrea Burkhardt. I'll link their videos onto the description because I believe they covered this appeal process really well and very detailed. So you can go check them out. As for me, I'm only going to be looking on one specific argument that a lot of Amber Heard defenders tend to run to, and in my honest opinion is probably her best argument, and that's, you know, saying a lot because even her best argument is not really a good argument to even begin with, and that argument is mainly the foreign non-convenience argument. She brought this in 2019, I believe, and Judge White, not Judge Penny Ascarate, as a lot of Amber Heard defenders tend to think that she was responsible for this decision. It wasn't her, but Judge White was the judge that ruled that Virginia was the correct forum to hold this case. He cited Virginia law in regards to having a printing press there and having servers run through there as well, which aids in hosting their online site. I think he is 70 to 80% correct on this one. The reason why I'm not 100% is because if it was held in Washington, it would have been 100% convenient venue in my honest opinion, because that's where the headquarters is. So the jurisdiction, I mean, well, it kind of makes sense for the venue to be there as well. So yeah, so on that front, that's why I am not 100%. But was he wrong? No, because end of the day, it is one of their locations, whether it's the printing press or where it's host the service, whatever it might be, it is still linked back to Washington Post, and they still did print the publication that caused the injury. So nonetheless, you know, I don't think he made the wrong decision overall, but I do think his judgment, in my opinion, is up for can I say scrutiny? Maybe not scrutiny. Maybe that's not the right word. I'm running out of words to actually use here, but I do think that argument is debatable, if I should say. But that doesn't mean it's wrong. I just want to. That doesn't mean it's wrong. It just means it can be debated. The main point I wanted to go on here is a lot of the people that are saying that Amber Heard should have had this case thrown out because of the foreign non-convenience argument incorrectly cite a personal jurisdiction argument, which is not what she raised at all in this entire case. She never raised personal jurisdiction. She just wanted to change the venue from Virginia onto California, citing personal jurisdiction, if that makes sense. So she used it as one of her arguments, but this wasn't her entire argument. She just felt that Virginia was the wrong venue to have this case. And I'm gonna be extremely hyperbolic here when I say, you know, as she made the personal jurisdiction argument, it probably would have worked out for her in the sense that because she turned up to VA, she basically waived that right, or waived or showed that there was no personal jurisdiction. She was able to get there. There was nothing stopping her from getting there. To better understand what I'm going to be talking about in regards to personal jurisdiction, I think it's fair that we glean a little bit from Judge White's opinion letter to understand why this motion was actually dismissed. So we're going to take a quick look at the analysis that Judge White had done in his opinion letter to address Ms. Heard's argument for the forum non-convenience. I'm mainly going to look at this because I believe that's what the appeals court is going to be looking at, the analysis, not necessarily the arguments, because I think, and I don't know, don't quote me on it, feel free to correct me as well, but I think they're going to be making new arguments for this foreign non-convenience for the appeals court to consider based on the analysis of the judge, because he has already decided it. So that's what I'm thinking is going to happen, because it's more of a matter of law, not necessarily making new arguments irrespective of the judge's ruling, and just argue that it shouldn't be there to them. So I could be wrong again, but I do believe that's what's going to be transpiring in the appeal. So the place of injury is not necessarily where the abuse took place, because I remember Ms. Heard even making the argument that the abuse took place in Bahamas, so therefore it doesn't really constitute Virginia at all. These incidents all took place outside, which doesn't really matter in this case, because libel, injury, or slander, or all those things is where can also apply to where the publication was printed, and that was mainly Depp's argument, Steve's argument, and that argument invoked the argument of the lex loci rule, which Virginia has adopted out of 10 states. I'm just quickly going to look at it because the Judge White actually analyzed this law to apply to this case. He made it clear that they are following a rule that Virginia does adopt, and he goes on to say Virginia is one of the 10 states that still adheres to the lex loci rule. As states still traditionally using the lex loci rule, taught are Alabama, Georgia, Kansas, Maryland, New Mexico, North Carolina, South Carolina, Virginia, West Virginia, and Wyoming. So application of the lex loci delicti rule defines the place of wrong for defamation cases as where the publication is concerned. So that's the main idea. That's the main thinking behind the rule. Is more of, if this happened here, it can be applicable here. Judge Hudson of the Eastern District of Virginia examined the application of Virginia's lex loci delicti rule, and this rule was passed in the case of Cockrum versus Donald J. Trump for president. So this is it's a 2019 case. So I think this is a case that is very relevant in today's time. So this case would be pretty important and closely analyzed, in my opinion, if she's going to be successful with appeal or, unsuccessful. I think this would be the case that they may be looking at before thinking of setting a new idea or creating a new test or a new law in regards to this, because the case says the plaintiffs in Cockrum sought damages from the unauthorized publication of their personal information on the internet, which was allegedly obtained by Russian intelligence operatives during the hack of computer servers belonging to the Democratic National Committee. The court applied the lex loci delicti rule to the common law claim of public disclosure of private facts. Determining the place of the wrong is where the last event necessary to make an act liable for an alleged tort takes place. The court looked to the elements of the tort. Judge Hudson determined that the common law claim of public disclosure's place of wrong was wherever the act of public disclosure was published. Ultimately, he felt that the Supreme Court of Virginia would find that the place of the wrong in these claims for public disclosure of private facts is the place where the act of publication on the internet occurred. So, what this, from my understanding, from Hudson's ruling, because, and I could extrapolate here, because of the private nature of the abuse that went on is akin to having your private details leaked online that you don't really want to be leaked. It's not really public property. But again, with that application, there is the case that these abuse claims were leaked in 2016 to the public. So just by looking at that alone, it does present a little bit of problems, because if it was leaked to the public and it was really public information, her putting it in the op-ed again doesn't really fall for the test that was applied here in Cochrane, because from what I'm understanding, that test really does put it on the servers alone, not necessarily the printing press, but because it was published on Washington Post, it made, by that argument, I could be wrong again, by the lex loci applied by Hudson, it triggered the venues of Washington, Maryland, and Virginia to become active venues to choose from, because again, it was published on the Washington Post, and it was distributed from there, and it was private information. So if it was already public in 2016, my thoughts are it can't be. It's like having your details already already revealed, not by you, by the way, by the defendant in 2016. So having those details revealed at that time has already made it public information and has already had people discussing it. For example, at that time, in terms of the libel injury, for example, in terms of the defamation, it had already, not defamation per se, but because this claim was brought in 2018, so not this defamation, but the idea that the private details were already online. All that's happened is Miss Heard just took those details online and put it here. It really doesn't matter if you want to argue republication, because Virginia statute has already made it clear that republication and publications, or the statute of limitations, is literally as it was published, not necessarily when it was previously published or repackaged. So that one wouldn't count, because you can't go back in time to pursue a case that someone decided to bring forward again. That doesn't make sense according to my understanding of the statute. It's very clear, and it makes it that any republication and publications are tried as they were published. But my point mainly is this rule cannot, by Judge Hudson, cannot necessarily be applied, simply because of the fact that it was already public information in 2016, and it makes it a very gray area again to be considered by the Court of Appeals, and a new rule might need to come out of it. But I believe this is the one case that does make it very clear-cut in terms of how to handle online matters, because again, Judge Hudson did rule here that the idea of the Russian operatives leaking private details online, and with it being the place of publishing in Virginia, because of the private details being leaked online, it does warrant Virginia to be the place of injury, and to have the case tried in Virginia courts. Although the common law claim of public disclosure of private facts differs from defamation, both torts hinge on the publication of private information or slanderous words. Both torts require the element of publication before any cause of action can accrue. Application of lex loci delicti, can't pronounce that. The place of wrong requires the court to determine where the last event necessary to make an act liable for an alleged tort takes place. The last event necessary for an individual to become liable for the defamation in online multi-jurisdictional cases occurs when the defamatory statement is uploaded to the internet. Therefore, the place of the wrong in this case, and this is the important part, is the place where the act of publication of Ms. Heard's op-ed to the internet occurred. The court will now examine whether the facts support the place of the publication to the internet as being in Virginia, California, New York, or elsewhere. So I don't know how New York got brought into this, but just to give a quick summary, the reason why New York is actually mentioned is because of the ACLU, which has domain in New York or headquarters in New York, and because they were the ones that essentially wrote this op-ed. It wasn't actually misheard that actually wrote it. It was the LCLU that quote unquote ghost wrote it, but misheard was the author because it was her going to them. So that's where all of this is up in the air, and New York is now an active venue based on that information. So finish off the opening letter by Judge White. He says publication sufficient to sustain a common law defamation is uttering the slanderous words to some third person so as to be heard and understood by such person. Ms. Heard's op-ed was uploaded to the internet through the Washington Post service located in Springfield, Virginia. So the course of action arises in Virginia. That was the argument from Depp's side. Ms. Heard's declaration on this record, to which the court cannot add or infer, states that Ms. Heard submitted our op-ed to the Washington Post through her contact at the ACLU, who was based in New York. Our op-ed was then published on December 18, 2018 on the Washington Post website. Heard's act of emailing the op-ed is similar to sending a letter through the mail. Ms. Heard merely submitted her op-ed to our contact in New York, and the court cannot assume facts that are not in record as to what the recipient did with the op-ed, except that the op-ed was published on the Washington Post website at Ms. Heard's instruction. So that's pretty much clear that she gave the green light. For this op-ed to be published. So irrespective of ACLU being the writers or the ghostwriters of it, it doesn't really matter. She gave the green light to have it happen. If she said no and they went out and published anyway, this is a very good argument to say I'm not liable for this because I said don't publish it and they went ahead and published. So he should have brought the case to ACLU and not me. Do you know what I mean? So even if they were to use her name, this and that, that would be a separate case between LCLU and Amber Heard to fight in terms of, okay, you stole my identity, there we go, blah, blah, blah. That would be a different case. But that didn't happen. If that happened and the case went ahead anyway and she had to sit trial because it was her events on it, and the judge ruled that's okay, even if she didn't submit it, this would be a failing of the law and she would have more of 80% chance of winning it on appeal. But that didn't happen here. The Washington Post online edition is created on a digital platform in Virginia and routed through service in Virginia. Like the private information that was directed to be published online by defendants in Cockrum, Ms. Heard submitted our op-ed to the Washington Post to be published online. The last event to make Ms. Heard liable for the alleged defamatory statements in our op-ed was uploaded it to the internet using a service located in Springfield, Virginia. The Washington Post posted it to the internet on December 18, 2018. Therefore, Mr. Depp's course of action arises in Virginia and prerequisite to dismiss the case based on the forum non-convenience is not met. So I think, and I could be wrong here, because she alleged that this should be in California or New York, I think this is where she messed up. Because if she said, let's take this to Washington, I think she would have had a better case to have this case tried there. And if the judge rejected that and still went with this ruling, it would have been a toss-up on why it didn't go to Washington, because I think Washington doesn't have this rule in place. it was only Maryland that has the lex loci rule. Just based on the fact that she chose the Washington Post alone was a massive L, because each 3 locations that she could have picked are very weak for anti-slap. And just based on that alone, I don't think she's going to win this argument. She may have a chance in regards to what I argued earlier in terms of arguing that the information based on, because as we read here, the judge actually ruled on the fact that it was going with Cochran on this idea that it was the servers. It went with Cochran and sided with Depp's argument in regards to not just having the servers there, but printing as well. So that's why it was held in Virginia. So Cochran is the main idea or the main case to look at when examining this case. So it made it possible for New York to be considered, but I don't think the judge really erred by saying New York is not going to be the appropriate venue simply because it wasn't published there. Yeah, sure, the injury occurred there because it was written there. You can argue that, but no one knew. So the idea here is, unless you published it through the New York Times, no one is going to know that you are even going to write this. And because you published it on the Washington Post, that's when everyone knew. So that's the main idea. And I think he applied that correctly. I think he used the correct case law for it, because not only was it modern, it was literally, it's Donald J. Trump. So not only is it modern, it's 2019, but it's also allows the judge the leeway to not be challenged on the relationship that Depp has with Virginia, because that wasn't really established in the Cochran case. It was just the fact that the private details and was published, and Virginia was the place of injury. So they used that idea with the Washington Post. Miss Heard and our contact in New York both share the corresponding interests and reciprocity because they are working together for the LCLU. Thus, their publication did not occur until December 18, 2018, when the op-ed was uploaded to the internet on the Washington Post website. It was only then the allegedly defamatory statements were read by non-interested third parties following Judge Hudson's opinion and consistent with the Supreme Court of Virginia's president. The court finds that publication occurred in Virginia. For these reasons stated above, Ms. Heard's motion to dismiss based on foreign non-convenience is denied. Mr. Depp's counsel is directed to prepare for the order reflecting the court's ruling and forwarded to Ms. Heard's counsel for endorsement and transmitted to the court for entry. Like I said, she didn't raise a personal jurisdiction argument. She only raised a foreign non-convenience argument, in which I believe that Judge White got that correct. On this occasion, there is actual statute, a VA statute, that does say you cannot argue jurisdiction with venue. So therefore, it's on appeal. So therefore, it is basically a null and void argument when you look at that statute. What we're gonna do is look at the Code of Virginia, which I believe Judge White cited, and basically just go through it and just read it. So basically it says venue generally, this is VA statute 8.01257. It is the intent of this chapter that every action shall be commenced and tried in a forum convenient to the parties and witnesses, where justice can be administered without prejudice or delay, except where specifically provided otherwise. Whenever the actions is used in this chapter, it shall mean all actions at law, suits in equity, and statutory proceedings, whether in circuit courts or district courts. Like I said earlier, Judge White ruled it based on the fact that they have office that does do their printing, as well as they have online servers going through there. So I don't think he is actually misinterpreting this statute or code. Also, if they really want to argue this whole personal jurisdiction and Amber not having a personal jurisdiction over in VA, then they kind of have to look at the holy and sacred UK case that they keep throwing in everyone's face, because let's admit it, it's where the sun is, and it was the forum convenient for the sun to have that case there, because they are based in the UK and they printed this in the UK, the same way that Judge White basically argued. I mean, he didn't even have the UK case to even go by at this point, but you can see the connection here, that because it was printed and published and posted in Virginia as well, it's the convenient venue for that. But we both know Depp and Amber Heard are not from the UK. They don't have residence in the UK even at the time of the incident. It was in California. So this argument, in my honest opinion, is moot, and really personal jurisdiction really bears no relevance, because if you really want to compound everything and bring everything together, Amber's appearance in the UK, a different country, she traveled miles to be there, shows that she's able to get to Virginia, or she's able to even attend, and she did attend in Virginia. It just, to me, it just falls flat in terms of arguing personal jurisdiction, because quite frankly, there is no argument to be had. In my honest opinion, it's not like she didn't turn up to the sacred UK case, or it's not like the son was based in the US to even have that case tried at all. So again, this falls flat on his face. But there is one section of that code that I do want to take a look at, and it's chapter 8, section 248, which says venue not jurisdictional. It goes on to explain what it means by that. It says the provisions of this chapter relate to venue, the place of trial, and are not jurisdictional. No order, judgment, or decree shall be voidable, avoided, or subject to collateral attack solely on the ground that there was improper venue. However, nothing herein shall affect the right to appeal an error of court concerning the venue. So they can appeal concerning the venue, but they cannot really appeal based on jurisdiction, or in this case, personal jurisdiction. It would be a different case if she raised it, which is what I was talking about. But they're making it clear, you raising a foreign non-convenience argument is not the same as personal jurisdiction, and it doesn't have relevance to personal jurisdiction. They can still appeal regarding a misapplication of a wrong forum law, or let's say, for example, there was no printing press in Virginia, for example, but the judge ruled that it was just a service that ran through. I think they would have a right to say that's the wrong venue, because there is no way of proving that the people of Virginia had a chance to even read this about Depp, for example. It makes sense why you can't even bring up jurisdiction at all, because again, they're making it clear personal jurisdiction should be argued separately, not for the venue. And as they have stipulated within their arguments, they were trying to move it from Virginia to California. So that's basically all I wanted to say. And in all fairness, I think it's pretty airtight. I do think the judge did get it right on this occasion. I do understand that Rowanborn tried to use the actual print that was printed in Virginia and not the online version, which, I mean, it's a good strategy. I'll give him that. But nonetheless, the words that were in the print is the same words that was on the online version. So the only difference was the titles or the headline, which is a different argument, but that's the only difference. And even with the difference in the titling, the titling of the headline for the online version versus the print version, it goes to show that the paper knew what they were doing to get the most amount of reach using online, etc. So in my honest opinion, they knew what they were doing when they were approaching this issue, in regards to who gets to see what, basically. But yeah, that's all I have for today. Thank you so much for watching this video. Do share this video. I'm not gonna be doing a lot of these videos like short form. I just really had to get this one off my chest because I think on his face is just the dumbest argument. I'm not gonna be touching anything of the appeals until I get the appeals brief. But if they're going, but it's just for the fact that I've just been seeing some asinine master posts arguments in regards to the appeal, so I just leave it regardless. So it is what it is. I'm just gonna wait till the briefs before I do a rundown. Do check out my other videos on the channel that I've covered. I've got plenty more videos coming. So if you haven't subscribed yet, do subscribe. Thank you so much for checking out this video. Even if you liked it or didn't like it, I appreciate you for taking the time out to watch it. Don't forget to like this video and share this video on your social media. And thank you so much again for watching. Have a good day and take care.